Okay, so I'm very excited today to be joined by James Youssef, who wrote a report that really stood out to me. James is currently a lawyer and former director of policy at the IRCC and a former adjudicator at the IRB. So someone who's very qualified to be talking about or having the conversation around Canada's asylum program and the asylum policy and what things that are happening in there right now. So I think if we could, probably the best place to start is if I missed anything in the introduction of you, feel free to backfill any of that. But I know you gave me a bit of a history on this. If we could start with how did we get to where we are and kind of contextualize what is the IRB and maybe the concerns around its independence first. And I know you kind of added a couple of key dates of how we kind of got there. If you want to set all of that context and then we can get into the discussion.
Sure. And thanks very much, Daniel, for having me. So Canada has an immigration department, an immigration minister, IRCC. But Canada also has a separate tribunal called the Immigration and Refugee Board. And that's the place where asylum claims are adjudicated. The Refugee Protection Division is one of four tribunals that are located at the IRB. And the IRB came into existence in 1989 as the result of a decision of the Supreme Court in a case called Singh, which required that asylum claimants must have an oral hearing. And so the impetus for the creation of the IRB was that decision. But the IRB was created with an extraordinary degree of independence. It does not sit in a direct reporting relationship to ministers, not the Minister of IRCC, not the Minister of Public Safety. It reports to Parliament through the Minister of Immigration, but it's really quite independent. In terms relative to other department agencies, it's somewhat disconnected from government. And it has an extraordinary degree of independent power to develop its own policies. If you were to compare it to jurisdictions like France, the UK, Australia, New Zealand, the asylum tribunals in those jurisdictions are independent to an extent which is necessary for a tribunal. But they sit in a direct reporting relationship to ministers and to cabinet. And it's ministers that set asylum policy, not the tribunal itself. So I think that may be helpful background. That the model that we have in Canada provides an extraordinary degree, even an unusual degree of independence to our Immigration and Refugee Board.
And sort of stacked on top of that, there's a couple of issues outlined in the report, and the accountability or independence is a part of it. And then the other piece that I think is more public facing and people seem to point out a lot more is that there was this backlog issue, and that, you mentioned it hasn't necessarily been solved, and it's not a new problem, right? Like the backlogs at the IRB didn't start yesterday. They've sort of been a recurring issue since at least 2013, I think you mentioned. So what went structurally wrong and still hasn't been fixed by this like kind of new system that we have right now?
Yeah, there had been very long-standing problems with a backlog of asylum claims at the Refugee Protection Division of the IRB going back quite a long time. There were significant reforms that took place in 2010, and those reforms resulted in a lot of resources being put into the IRB, as well as a lot of new decision makers. And that was part of a broader package of legislative reforms that were passed in 2010. And that new system came online in 2012. And by 2017, a second backlog had emerged at the Refugee Protection Division. It had been unable to fulfill the rate of decisions that it had committed to in the context of the reforms of 2010. And I think at that point, there may have been a kind of collective sense of frustration on the part of government as a whole.
And then they made some changes in 17, and I guess your report sort of argues that the policy hasn't necessarily accomplished, or they added this file review policy and there hasn't been positive outcomes, right? So can you tell me a little bit about like sort of what changed, what was their objective of their goal in solving this, and what was the actual?
Sure. So there's one detail that I'll provide first, just by way of background. So in 2017, the Trudeau government commissioned an independent review of Canada's asylum system. And this review was led by former IRCC Deputy Minister Neil Yates. And he had a mandate to consider all options. As I say, I suspect there was a very strong collective sense of frustration with the reforms of 2010, 8 or 9 year effort to try to better resource and address this issue of backlogs. Had come to an unsuccessful conclusion. And Mr. Yates had a mandate to consider all options. And his report came out in 2018 and essentially sets out two broad options. The first was to basically leave the system as it is and maybe resource it a little bit better, or what he referred to as major structural reform. And what he is referring to by major structural reform would have meant basically dissolving the Refugee Protection Division, moving it out of the independent IRB model, which I think had come to be regarded as an awkward and difficult model for many reasons, and transferring Canada's Asylum Tribunal back to IRCC, back to the Immigration Department, where it had existed before, which would put it in a direct reporting relationship to the Minister of Immigration and just make it a lot easier for government as a whole to try to improve the system. So the reason that's important as a background to the policy, which is the subject of my paper, is that when Mr. Yates went in 2017, I mean, I think there was a kind of sword of Damocles hanging over the Refugee Protection Division. They were, because those options were on the table. And if the Refugee Protection Division was going to survive this review, they were going to have to increase their rate of decisions very quickly. And so they were under immense pressure in 2017.
And as it stands now, the result of a lot of these things that happened, how has that been? I guess that sort of brings us to sort of the meat of this report is like, what's broken here? I know there's, we can get into a whole host of discussions, but sort of let's like start from the top of like, obviously the outcome wasn't as intended, or there's, what does it look like now? And what are the major challenges that you see with the way it's structured?
Right. And so now we get into what the IRB did to try to survive the Yates review. They needed to quickly increase their stats. And what they did is they implemented a policy which eventually they called file review. And this is a policy through which they began to accept asylum claims without conducting hearings. Let me just pause for a second to explain something. So a positive decision can be made very quickly at a refugee hearing. If the evidence meets the legal test, the adjudicator can take a short break, come back, read a positive decision into the audio recording of the hearing, and the file is very swiftly closed. A negative decision rejecting a claim for asylum has to be written because it is almost certainly going to be appealed either to the Refugee Appeal Division or the federal court, or both. And that means that a negative decision has to be carefully written, which takes time and takes more resources. So if the IRB was going to increase its stats quickly in an effort to survive the Yates review, it might have preferred positive decisions. And that brings us back to the policy of file review. With file review, the IRB implemented a policy that basically giving itself permission to accept asylum claims without conducting a hearing, without having the claimant come in person, without asking the claimant any questions. They created a policy in which it was possible for their adjudicators to simply look at the paper file and decide whether or not they think the claim is well-founded and rubber stamp a positive decision. And that's what they did. And in a short time, they more than doubled their stats and they survived the Yates review.
And after you get through this sort of like the issue with the file review side of things, there's maybe some negative externalities you might want to point to as a result of this maybe not being the best way to do this. So I think I'll sort of rifle them off and we'll maybe start from the top, but I know there's sort of the issue of like testing the evidence. So you can't really tell a true claim from a false claim. There's issues with potential national security and fraud, obviously. The high acceptance rate you noted as a bit of a concern that could be a bit of a vulnerability and a pull factor. and sort of the institutions incentives themselves, right? That you mentioned, I think, or a little bit earlier at the beginning there, and sort of like ramping up the stats. Let's start with with number one, which is sort of we can't tell what the credibility of the claims, right, without testing the credibility in person. And why do you feel that that's such an important piece of the refugee determination?
So, but you can't tell whether an asylum claim is true or false just by looking at the written record. All asylum claims, when submitted in writing, are going to contain a story or a narrative, which, if the tribunal accepts in evidence, will in all likelihood meet the legal test and result in a finding of refugee status. So, I mean, the fact is that on the one hand, there are unquestionably legitimate refugees, bona fide refugees, who do need Canada's protection. And it's really important to stress that. On the other hand, there are also people who pretend to be refugees in order to gain access to citizenship in Canada. And we know that we have both. And you simply can't tell from the written file whether the claim is truthful or not. You have to conduct a hearing and you have to question the claimant. You have to examine the documents in the file, which may be false or forged documents, and put those documents to the claimant in the hearing and ask questions about them. It's just the rudimentary, basic ask questions to get a sense of the truthfulness of the claim. And it doesn't take long to get a sense for whether or not the claimant is being truthful or evasive, or whether the testimony is consistent or not. But that can't be determined just by looking at the paper application alone.
And this has sort of led to, the chart that I posted that sort of catalyzed us having this discussion with your team showed the acceptance rate going from a much lower number to now nearly 80%. And, some might say this is a sign of a great humanitarian program and a strength. Others might argue that it could be a systemic vulnerability. And I think you mentioned a bit of like a pull factor, right? That it's maybe something that it would attract people with hopes that they would get an acceptance. And then there's, the consequences of that we can discuss afterwards. But what, like the acceptance rate how did it get to where it is now? And what are the issues associated with that as it stands?
So, the policy of file review was piloted in 2017. And then it was formally announced in 2019, and it's still running today. In 2016, the backlog of asylum claims to Canada was about 17,000. Today, the backlog of asylum claims is about 300,000. So during the period of time in which the IRB has been rapidly accepting claims without asking any questions, I mean, I think there's a pretty strong case to be made for the proposition that insofar as this policy was predicated on reducing the backlog, it's failed. I mean, the backlog has increased by about 1,400% since the policy was introduced. And then, as you say, more broadly, during this period of time, not just with respect to this particular policy, but overall, Canada's acceptance rate has now risen to 80%. And to place that in context, Ireland has an acceptance rate of about 30%, and Sweden has an acceptance rate of about 40%. And there are studies that show that perceptions of the relevant difference in acceptance rates between different countries is a significant factor in the choice of jurisdiction made by asylum claimants. And what that means is that by making it so easy to gain asylum in Canada, these policies of the independent IRB may be having the effect of attracting more claims to Canada, the opposite outcome of what was intended.
And yeah, I guess that could be maybe the reason the backlog has grown as well, right? Is that you get people attracted to the high acceptance rate and you get more applicants. And then I think that, the other issue when you see a high acceptance rate and a sort of low scrutiny level on files is these risks associated with it, right? So, you sort of suggested that there are risks with fraud and security to accepting claims without hearings. Can you explain sort of how skipping a lot of that in person scrutiny could weaken safeguards and what the consequences might be for Canada? Because I know we've heard issues in the news of stuff like this, right?
Sure. So the Minister of Public Safety has a mandate to intervene in any asylum hearing at the IRB with respect to security and related issues to that minister. The Minister of IRCC, that is the Minister of Immigration, also has a mandate to intervene in any asylum hearing to deal with issues of program integrity, such as fraud but they don't have the operational capacity to be present in every asylum hearing. There are too many of them. And so they have to be selective about the cases that they intervene in. And so Canadian law contains a notification mechanism, and it works like this. There's supposed to be a hearing for asylum claims, and the default is supposed to be that claimants are questioned. And what will happen is, over the course of questioning, say a red flag of some kind may go up, like a security flag. The claimant provides information that suggests that there may be a security risk associated with the claim. And Canadian law requires the IRB at that point to halt the proceeding and notify the Minister of Public Safety to give them an opportunity to intervene. If it was a fraud or program integrity risk, the notification would go to the Minister of Immigration. If the IRB is accepting asylum claims without conducting hearings, and I should pause to say, my research showed that between January of 2019 and February of 2023, the IRB accepted 24,599 asylum claimants without asking them a single question. That was for that limited period of time. And we know that the policy has been ongoing, and presumably the number today would be much higher. So back to the security point. If the IRB is accepting asylum claims without asking any questions, without conducting a hearing at all, the notification mechanism for the Minister of Public Safety can't be triggered. The policy nullifies the intervention mandate of the Ministers of Public Safety and the Minister of Immigration. And for that reason, clearly it increases risk to Canada.
Okay. Yeah, I have two more questions. I'm trying not to get too excited about this stuff because it's surprising. And I think I didn't know most of this. I've heard of and seen problems, but I think that the average Canadian needs to know and see this stuff. We talked about the fix, right? It's really easy for us to drone on and on about the problems that are facing this thing, but it's much more productive, I think, to imagine scenarios in which it could be better. So if you were designing the system or reform today, what would you do? And what do you think is a likely outcome here? Should they eliminate file review entirely? Should they, change the reporting structure to something closer to the 1989 model, like you mentioned? Reporting directly to ministers, what's a better version of the system? I know you made some recommendations in the report.
Yeah, I think the policy of file review is extremely problematic and should come to an end. That could happen. That could happen any time at the stroke of a pen by the chairperson of the Immigration and Refugee Board. But more broadly, I think that Mr. Yates in his 2018 report got it right when he suggested that the tribunal should be moved from its current independent structure, disconnected from government, and transferred to a department. Mr. Yates suggested that the tribunal be transferred to IRC so that ministers and cabinet have visibility into tribunal operations, which they don't. It's remarkable, and I can't stress enough how unusual Canada's model is. Ministers cannot see into what's going on at the IRB. It's totally opaque. It's really unlike any other department or agency. So the fix would be to do what most other countries do: reconstitute the Immigration and Refugee Board and its 4 tribunals into a departmental structure where there's basic ministerial oversight. Let ministers set asylum policy and not the tribunal itself.
Okay. Yeah, it's an excellent point. And I guess then the opposite of that question is, if this policy continues the way that it is, what are the long-term risks, not just to, asylum integrity, but also I think a big concern right now is they think the immigration file has been subject to a lot of criticism, and much of it is due and much of it has been corrected, I think. But this is one of the final components that has really been, I think it keeps moving to sort of like the next biggest problem in the system. What are the long-term risks if policy continues the way that it is?
So I think you're right. I think that there's a risk with a policy like this of undermining the public's confidence in Canada's immigration program, which is so important in a country like Canada for citizens to have confidence in the integrity of that program. So that's certainly a risk. In terms of what will happen if the policy is permitted to continue, I think the backlog will just get bigger and bigger, which is sort of the paradox of this policy. By accepting claims so quickly and in such high numbers and making it so easy to gain asylum in Canada, in an effort to reduce the backlog, the effect of the policy may have been to attract more claims to Canada and increase the backlog. So, I mean, it seems to me that the faster that the IRB accepts claims and the more aggressively it pursues this policy of rapidly accepting more than 80% of asylum claims, the worse it's going to get.
Do you think they're going to make any changes? Like, you feel like there's some progress as a result of your report? Has it been well received by your peers and the people who you need to be paying attention to it?
I hope so, but I have no idea.
Fair enough. Probably too early to tell. Thanks a lot for your time. I really appreciate it. And I've learned a ton. So is there anything that you feel like I left out that I didn't ask? Any questions you wish I asked, or anything you want to leave the audience with?
There's one thing I'll add, Daniel.
Sure.
And that is the effect of the policy on the people responsible for making the decisions, the board members, the actual adjudicators who are responsible for deciding cases at the IRB. The effect of this policy. So, I mean, it's a tribunal of law, and these are supposed to be independent decision makers. I mean, a policy like this, it would be like a criminal court judge who decides 80% of all cases are guilty, not because of the facts of each case, but because the judge has been provided with a quota of guilty verdicts. And if the judge doesn't meet the quota, his or her job might be at risk. With this policy, the IRB has been twisting the arms of its board members, its adjudicators, into making fast, positive decisions in ways that are unlawful or contrary to the law of administrative tribunals. One of the words that could be used to describe it, legal terms, is fettering. They're pushing them in the direction of a particular substantive outcome. More broadly, I mean, this is a tribunal of law. It's not supposed to have a preferred outcome.
Right.
It's not supposed to prefer positive over negative decisions. And the notion that it has implemented policies that have the effect of pursuing one substantive legal outcome over another, I think goes right to the core of the adjudicative integrity of this institution. There are a lot of good people who work at the IRB, and I regret that they've been placed under this duress to produce a particular kind of outcome, as opposed to being given the freedom to assess the evidence in each of their files and decide independently.
Yeah, I think it is a shame as well, especially like if, as we mentioned, sort of the trust in Canada's immigration system. I mean, you've got citizens are often looking for someone to blame, and it sounds like, unfortunately, they would be in the line of fire in that kind of thing, and by no fault of their own. So it is an unfortunate outcome. Thank you for your time. I really appreciate it. This has been super eye-opening for me, and I think for anybody who watches it, they're going to learn a lot. And this is something that I've just started paying attention to, I think, on the asylum claims side of things. As population growth kind of started to roll over and we've really been seeing a meaningful effort to shrink the temporary foreign worker population, it does seem like it's a part of the system that might be, subject to abuse next on the list. And I personally am of the opinion that it seems like there's a pretty pragmatic approach to changes on the immigration file in Canada, and I'm optimistic. And after I saw what you had put together, it made me more optimistic because I think that was the best description of and things that I had never even realized were taking place, right? But I just sort of, as an outsider looking in, could see that there's a bit of an issue arriving here. So I also just want to say thank you for putting the time and energy and effort into that report. And I would encourage, I'll make sure to put a link below for everybody to read it. I would encourage everybody to really dive into the report, because I think that it's a story that needs to be told. So thanks again.
Thanks very much, Daniel.